Thank you so much. Well, I have the distinct privilege and pleasure of introducing our Chief Judge, Loretta Preska, who is here to give her opening remarks and start off the keynote for the afternoon. First off, it's a pleasure to have all of you here. I'm going to give you an abbreviated version of her bio because she has an amazing bio. So if anyone has time, go into, just Google her. There are 45,100 hits on Judge Preska. Pick the top 10. But no, she has had an incredible career. She had gone to the College of St. Rose. She got her JD from Fordham Law School and a master's at New York University. She was actually in the private sector, two very well-known white shoe firms, Cahill Gordon and Winston Strawn, for 2 decades before George H.W. Bush appointed Judge Preska to the Southern District. And in 2009, she became our Chief Judge. Now, I want to talk a little bit about the incredible cases that the Chief has heard over the time that she's been there. One of the ones that I thought was very interesting, and it's been recorded repeatedly in the news, is the Leibowitz versus Paramount Pictures Corporation. I think many of you remember where Leslie Nielsen was portrayed in a parody of Demi Moore, and he looks like he's undressed, and that whole pregnant. Well, there was a case that was brought there before the judge, and the judge ruled that it was actually a parody, and therefore it was not defamatory, and the Second Circuit upheld the judge's decision. Judge also ruled in the Bloomberg versus Board of Governors, the Federal Reserve System's case that was brought forth, in which there had been a challenge to actually disclosing the recipients of the bailout. There had been that challenge. And Judge Preska ruled in August of 2009 that any attempts by the Federal Reserve not to allow that to be done any attempts to block the release of the recipients' names was set aside. So that's why we knew who actually had that received the bailout. Another very interesting case was, how many of you saw Captain Phillips? Well, Judge Preska ruled on that case. And actually, the Somali pirate Abdulwali News, I am butchering his name, I'm sorry, but Judge Preska sentenced him to 33 years in prison. Another very significant case is the case of Hector Xavier Monsegur, and Judge Preska also presided over his case in March, and he was the individual, the hacktivist that you may remember. He was the point person in Anonymous. How many of you remember the whole controversy regarding Anonymous and the leaks to WikiLeaks? Well, Judge Preska presided over that. The last one, of course, is Jeremy Hammond, where Judge Preska also presided over his rule in his case and ultimately ruled on his sentence. And without further ado, Judge Preska will give her opening remarks. Thank you all very much.
Thank you, Mercedes. And it's a pleasure to be here with all of you today in this beautiful venue and to see my friends at Gordon Reese. It's just wonderful to be here. I thought that I would follow up on what Mercedes was doing and tell you a little bit about our court. I know that you have all memorized your American history, and I know that you will recall that the Judiciary Act of 1789 created the 13 original district courts, the trial level courts in the federal court system. And of course, they were around the outlines of the 13 original colonies. What you might not have remembered is that the first federal court to sit in the entire country was the court that sat in New York City on the first Tuesday of November, 1789. All of you math whizzes out there know that if it was the first Tuesday in November of 1789, we have just celebrated our 225th anniversary and are having lots of events to do so for the whole year. Because we were the first federal court to sit, preceding the Supreme Court by 3 months, thank you very much, we are known as the Mother Court. So welcome to the jurisdiction of the Mother Court, ladies and gentlemen. In fact, the court did sit just a couple of blocks from here in the old Exchange building, which is, of course, also where the Supreme Court first sat. Now, those of you who have business in our court will not believe the report of the first sitting of the Mother Court. The news report of that day, of that sitting, read in its entirety, on Tuesday, the federal court for the District of New York opened in the Exchange. His Honor, Judge Duane presiding. No business being before the court, the same was immediately adjourned. Well, you all know that that's not the case these days. Those of you who aren't lawyers have memorized, I'm sure, in your American history class, that the Constitution gives federal courts jurisdiction to sit on cases arising out of the Constitution of the United States. So that could be freedom of press cases, like the Bloomberg against Federal Reserve case that Mercedes was talking about. It could be religion cases. I mean, we've all been reading about the Supreme Court's decision in Hobby Lobby, and now there's a follow-on case this year. Those cases all came from the lower federal courts. We also, of course, deal with cases arising out of the statutes of the United States. So the Annie Leibowitz case came out of the copyright statute, trademarks. Mercedes and her colleagues try so many discrimination cases. We have, of course, the discrimination laws. There are also the criminal laws of the United States, drug laws, firearms laws, identity theft, hacking. This morning, and it's going on as we sit here, the Speaker of the New York State Assembly is appearing in court to be arraigned on an information relating to taking payments. That just happened this morning. It's at our courthouse a few blocks from here. We have, of course, the terrorism cases arising out of those statutes. The World Trade Center bombing cases were tried in our court. This Tuesday, Judge Kaplan began a trial of an accused embassy bomber. You will also recall that, I'm sure you've memorized this also, the co-defendant in that case was the individual grabbed off the streets of Tripoli. He did pass away, so he's not on trial, but that case is going on. I know you've read of the Silk Road case, which was apparently an eBay for anything you wanted, drugs, anything else. That's going on in our courthouse now. And I can't read the rest of my writing, but in any event. The Somali pirate case arose. First, there was an actual piracy charge in that case. And who knew this? But piracy is one of those crimes that for hundreds of years at least, has been deemed so heinous that any country in the world may capture and prosecute a pirate, even though the pirate's activities had nothing to do with that country. So how interesting is that? In this instance, there were several other charges, and the individual was allowed to plead to the charges that did not carry a mandatory life sentence. His plea agreement, it is public knowledge, provided that if he was sentenced to 33 and a little bit of years or less, he had no right of appeal. So that is the situation we're in. I will tell you that he is still filing habeas motions, but he has given up his right to appeal. Some of you, and the Constitution goes on, but another item are things where the law needs to be consistent throughout the country. So bankruptcy is a good example. You have to have a consistent bankruptcy law. And so the Constitution gives federal courts the right to preside over those cases. And of perhaps some interest to you all, admiralty. You know, New Jersey cannot have a different admiralty law than New York. That would be a very bad idea. And so the framers put the admiralty jurisdiction in the federal courts. So Mercedes mentioned the Somali pirate. You will recall, and maybe some of you worked on, you'll recall that the vessel that was seized by the pirates was the Maersk, Alabama, very large vessel, container ship. Who would like to have been the claims administrator on that case? Horrifying. Or the 9/11 cases relating to property, the Trade Center and the like, were in our court. The American Airlines and the various airline cases were in our court. How would you like to be the claims manager on those? Fairly difficult. But that gives you an idea of the complexity of the cases. The Lehman Brothers bankruptcy was in our court. It's continuing. General Motors, American Airlines, all the big bankruptcies are here in the Southern District of New York. So it's not just because we are the oldest court, we are the mother court, but that's it. To give you an idea of running the court, many of my colleagues remind me from time to time that I did not become chief judge by divine right, brains, merit, or anything else. The chief judge is the most senior active judge in the court, so it's really timing. Now Justice Sonia Sotomayor and I went on the court together. Our commissions were signed the same day, and she recently reminded an audience of 1,000 people that I was older than she, and thus would always be senior. But so it's very random how one gets to be chief. One has a statutory term of 7 years as chief judge, and one has absolutely no power. The only power I have is to appoint judges to committees. The court is run similarly to some of the big corporations you work on. You know, the board of directors has committees, and all of the work comes up through the committees. I teach baby chief judge school from time to time, usually once a year. And one of the jokes is that we have more committees on our court than almost every other court has judges. So to give you an idea, bankruptcy, clerk's office, collegiality, criminal law, defender services, equal opportunity, house and space, judicial improvements, libraries, magistrate judges, media access, mediation services, pro se litigation, rules of practice, security, technology. Everything comes through the committees. Those of you who practice here in New York will recall that some years ago, probably on the neighborhood of 5, lawyers appointed to practice in our court were permitted to bring their cell phones in. Well, this was the result of a huge study that went on for 2 years as to whether or not lawyers should be allowed to bring in cell phones. There was not much agreement on the committee, and so a pro-cell phone report and an anti-cell phone report was prepared. We had a special meeting of the Board of Judges, debated it, and eventually the lawyers were in the clear. But that's how things work in the court. One of the other things I've learned in teaching baby chief judge school is that despite the size of our court, and we are, with another court, the largest, we have 28 authorized slots for judges. And one may then, you may also be a senior judge. If your age plus your years of service equals 80, you may cut down your caseload, become a senior judge, and that opens a slot for a new active judge. So with seniors and actives, we're at about 48 judges. What I have learned in teaching baby chief school is that we get along really well. You hear stories from around the country, but this is a big court, we have a lot going on, and just today, we're very, very busy. So That's what we do here in New York. I thought I would take 1 second to talk with the practitioners, the practicing lawyers here in the room. Just a few general ideas. My own view of coming to court, and this is of course for litigators, there are 2 basic rules. 1 is make it easy for the judge, and 2 is be a grown-up. Which is good advice no matter what, but why should you make it easy for the judge? Well, obviously the lawyer's job is to persuade the judge to come around to the client's position. So anything you can do to make it easy for the judge to come there is well worth the effort. Why be a grown-up? Well, number 1, the alternative is really quite unattractive. But again, what is your job? Your job is to persuade. So what you want to do is persuade the judge that you are a serious person with a serious case. The judge is not going to be so persuaded to go with you if you don't come across as a serious person with a serious case. So let's have an example or 2. Make it easy for the judge. The best example I recall was a sanctions motion. So let me just say, judges don't like sanctions motions. They don't advance the ball, they don't resolve the case, they're extra work. And at the end of the day, we really don't like to sanction lawyers. So right away, this is very unattractive. These lawyers came in literally on the eve of trial and asked if they could make a sanctions motion going to discovery abuse over the prior 2 years of discovery. Now, you're ready to face trial. Do I want to hear a sanctions motion? No, but long story, we did it. Make it easy for the judge. Sometimes lawyers looking for sanctions will come in and say, "Judge, you know what went on here. Give them sanctions." That's not very helpful, right? You're not making it easy for the judge. You're making me go back and do all the work and figure out what happened. Not these guys. The moving party drafted an affidavit of 60, 70, 80 pages, setting out in detail all of the outrages of the past 2 years. And remember, of course, it's harder to do 2 years than it is to do 1 or 2 events. 70 pages of outrages, accompanied by exhibits showing every order, every request, every letter, every single thing you needed to document what was in the affidavit. The other guys responded, and this is even better. Make it easy for the judge. Exhibit 1 to the reply affidavit was the moving affidavit, marked like a marked pleading. And ladies and gentlemen who aren't lawyers, when you have a complaint, you've got paragraphs of allegations. And sometimes you might mark it, D for denied, A for admitted, DKI, deny knowledge or information. But it at least gives you a snapshot of what the answer to those allegations is. What these guys did was they took the moving affidavit, and most of the pages said, undisputed, undisputed, undisputed. And where the allegation was disputed or something was said about it, there was a citation to where in the papers it was. Now, number 1, as you flipped it, it became obvious that there were almost no factual disputes on this motion. And number 2, make it easy for the judge, it showed us where to go to find what they had said. It was stunning, stunning advocacy. By the way, they did win the motion. But I bring that to your attention as something to think about. Most of you are dealing with probably fairly complicated insurance agreements, policies, riders, whatever it is. You probably want the judge to read it. My recollection of most of them is it's little teeny tiny type. Show us what you want us to read. Often you'll also get them two-sided copies, but bound at the top. So of course you have to do this. Please, show us what you want to. It doesn't make it easy. Show us what you want us to read. Sometimes it can be as simple as a mark in the margin or an arrow pointing it out. But help us get to where you want us to be. That's all you have to do. Have everything in the same package. So when we go for the weekend, we can take the motion along and it's all there. I mean, these days we can, of course, go on ECF and get it, but act like a grown-up. Make it easy for the judge. Just in writing citations, put your best case forward, give us the holding in the quotations, give us the pinpoint cite so we and the law clerks can find it easily. Don't string cite, it makes more work for us. We have to read all those cases. But how about being a grown-up? Again, you want to persuade the judge to adopt your position. Not going to adopt your position if you are not a serious person. Act seriously, don't waste the judge's time. Don't ask the judge for something you haven't asked your adversary for. Don't come in and plunk down the 60-page case that you say wins the case for you without telling anyone. You've wasted everyone's time. Everybody wants to read it. The adversary gets a chance to say something. Don't do that. You don't look like a serious person. Know the rules, the local rules. Check them all the time. It's easy to check on the website. Know the judge's individual rules. And I know you can't believe this, but there are some judges in our court who have rules against drinking water out of bottles. And I kid you not. And rules for where one may stand in the courtroom. Don't look like an amateur by not knowing what the rules are. And again, easy to check on the website. Check it each time. Then you look like a grown-up. And finally, your credibility as a grown-up is the most important thing you own. You get a reputation with a judge in a particular case, and then as you practice longer, you get a reputation in the courthouse. And if you think judges don't sit in the judge's lunchroom and gossip about lawyers, boy, you have another thing coming. But no client or case is worth losing your personal credibility as a lawyer. Another example you might be interested in. I had a multi-party insurance case some years ago. Jury is in the box. We are in the middle of trial. Lawyer came in the morning early with his adversaries, said he wanted to settle the case out from under his client. He had with him, having it distributed it to his adversaries, the policy language that he said permitted him to do it, and of course it was marked, I'll point that out, explained why he could do it, and said he wanted to do it. As you can imagine, to a trial judge with a jury in the box, news that you want to just cut it off and maybe get reversed is not good news. But this fellow had such a reputation with me in this case. Everything he ever said during the case about the facts turned out to be true. Everything he said about the law turned out to be true. So he had massive credibility. So I listened to him a little longer, read it a little more carefully, and eventually went his way. P.S. Court of Appeals affirmed. So that was good. But that's my message for you advocates. Make it easy for the judge, and please be a grown-up. I wondered if any of you had any questions. I'm happy to try to answer, or at least listen to the question, if you would like. Ladies and gentlemen. Oh, come on. Yes, ma'am.
Are there certain substantive areas that you like more than others?
The question is, were there substantive areas I like more than others? I would say there are substantive areas that perhaps are not as much in favor among judges. Fair Labor Standards Act cases are difficult. These are cases, obviously, on the Fair Labor Standards Act. Often restaurants and those kinds of businesses where there really are no records. And so that's very difficult. Social Security appeals are very difficult. The records are exceedingly large and very technical in the medical evidence. So those are hard. And you can never tell, though, what's going to be an interesting trial. Do I have time for one more story?
Sure.
Okay. So last summer, case comes in. It is a Hobbs Act robbery. I'm probably going to eat up all the question time, but you're going to love this. The Hobbs Act is a federal statute that makes it a crime to commit a robbery that touches interstate commerce. It doesn't have to touch very hard. So the testimony of the victim, a female, was, I was in my bed in my 2-bedroom apartment. 2 men came in, wanted my cash. Now, what was her business? Her business was the prostitution business. And the testimony, for example, as to interstate commerce, you laugh, but if we don't have jurisdiction, we can't hear it. Testimony was that she took interstate telephone calls, she advertised on the internet, and customers drove in from out of state. So we covered the interstate commerce aspect. They beat her, they probably raped her, and eventually she gave up the $11,000 in cash. A month later, the most unlucky defendant on the planet was arrested with her $100 bills in his pocket. How do we know, you say? Well, testimony was she had been in conversations with a pimp. He wanted her to come to work for him to make more money. She took her $11,000, arrayed it very neatly, the hundreds, the 50s, the 20s, on her pink tiger print bedspread and took a photo to send him and say, I don't need you to make a lot of money. Turns out the perp also took the cash home, put it on his different bedspread, it was checked, and took a photo. Later on, the assistant who tried the case told us she had been poring over these photos for months. Her eyes were bleeding, trying to find a smudge, a tear, something that could connect it up, but alas, nothing. 3 days before trial, she remembered that cash had been taken from him when he was arrested. She called for the cash. She said, I knew those serial numbers. I just had to look at it, and I knew. And don't you know, they blew up her photo. They showed the cash. The serial numbers matched. Can you believe it? Can you just believe it? They also had cell location information out of the perp's cell phone that showed him in the area of the robbery. But you can't make this up, right? So who knew that was going to be an interesting case? Okay, maybe one more question?
Sure.
I don't want Mercedes to get the hook. Yes, ma'am.
What would you have done differently as a baby judge, like you said?
What would I have done differently as a baby judge?
That's a good question.
That's a very good question. I think I would have been tougher on the lawyers with the deadlines and whatnot. I mean, I am still so cognizant of being a practicing lawyer and the demands that are put on people, and I know it's worse today than 20 years ago when I went on. But maybe I should do that. But maybe that's all. Anyone else? Thank you, ladies and gentlemen. It's a great pleasure to be here.